Hi, and welcome back to the second video in our Help Us Say Yes webinar centred around electronic evidence and PPE. In this video, myself and my colleague John are going to explain about electronic evidence, going through the remuneration regulations, some case law and the assessment process. So, back in 2011, so prior to the 3rd of October 2011, it was all relatively simple. If you had material that had been served in an electronic format that was used materially in your case, it was not subject to payment as pages of prosecution evidence. However, a supplemental claim could be made under the special preparation provisions. As you know, special preparation is claimed on an hourly rates basis. Moving on to move with the more digital. In order to update our legislation and move to a more digital era, because more things were being served on disk or USB, the regulations were changed on the 3rd of October 2011, and they were changed to say that if you have material that has been served on disk or USB for convenience, so if it was something that would have been traditionally served in paper, such as a statement, a photograph, a transcript, a man-made report, etc., that would be included in the PPE as opposed to being subject to special preparation. However, if you had any material that was in a electronic format, and it was always in electronic format, so if it's something like an Excel document, telephone data, telephone download, etc., under that regulation at the time, that would not be payable as PPE, but it would be subject to special preparation. Moving things forward to the 1st of April 2012, the regulations were then changed again to compensate for the fact that more material was being served in a digital manner. So the regulations from 2012, and as they stand now, is that if you have material that is served in a digital format, and it's always been in a digital format, it can be considered as PPE if it's deemed appropriate by the determining officer. So it's Part 1, Schedule 2, Paragraph 1.5 of the Criminal Legal Aid Remuneration Regulations, which is key here, as well as the case of R versus Napa. So from 2012, what we do is if you have material that's always existed in an electronic format, it does have the capability of being paid as PPE as opposed to special preparation. However, it does need to meet a two-part test and it's not automatically going to be classed as PPE. So now you're probably thinking, well, what is that two-part test? So the first thing that we would look at is, has the material been served as used material? So we'd need to see, is that material on a notice of additional evidence? Is it on a letter from the CPS? Is it on the digital case system, etc.? So is there some kind of documentation with that material to verify that it is used material by the prosecution? If that part of the test is then satisfied, we will then look at whether the material is relevant to the case, which is why your submissions and the breakdown of the material, as well as the material itself being sent to us, is of key importance, because if we don't have that information, or if we don't have all of that information, that is when we will be making assessments. And as you know, especially under the litigator fee scheme, PPE is one of the main proxies for payments. So if we're assessing down the PPE, it can lead to a harsh reduction, and we don't really want to do that. We want to have the information there in front of us with your claim first time round, so that we can make an assessment and pay you as close to in full as humanly possible. You might hit some stumbling blocks in terms of the material itself and whether it has been served or not. Obviously, we are aware that sometimes the CPS do not always formally serve notices of additional evidence with material, and also sometimes material can be classed as unused material, but then during the course of the case, it can then become used, and then there is no physical documentation to verify that. If that does happen, the case of Lord Chancellor versus SVS solicitors is of key importance. So what we would advise you to do is initially speak with the CPS to see if you can get a formal agreement of what the pages of prosecution evidence are and what material has been classed as used and what is not used. If the CPS are unwilling to engage, the next port of call would be for you to raise it with the raised the issue with the trial judge at the time that the material was introduced, just so that the trial judge can either make a ruling or make a note in open court as to whether the material is going to be classed as used or unused. Now you're probably thinking, how are the LEA going to know what the judge has said in court? We do have access to all of the court logs, so we can see what has been said in open court. So if you do have a situation where this occurs, can you just let us know what the date of the hearing was? So then we can look at that on the court log to verify that information. If unfortunately the trial judge and the CPS are unwilling to say that the material is going to be classed as used material, we do have to treat it as unused material. So therefore, if your rep order is granted prior to the 17th of September 2020, there will be no remuneration available for unused material. However, if it's after 17th of September 2020, you can submit an unused material claim to us, and there will be further information on our website about that.
Thanks, Jen. Obviously, looking at box 1 on our slide 19, the most important aspect of the case for you in terms of getting your PPE figure, has all the required supporting documentation being uploaded to us. We were unable to make an assessment fully and effectively if you haven't submitted the full electronic evidence files, or have failed to submit the LAA report or the NAE, etc., that shows that the material has been served on the case. The caseworkers will walk through a process similar to what is on slide 19. The second box has the material in question being served as used. That again goes back to the cost of decisions Jen just spoke to you about, the SVS and NAPA. And third box, when the material was served if it's during the trial, again, as Jen mentioned, we can go through the court logs in order to find that material. Fourth box is, can the material be viewed? Obviously, we've talked lightly on our last video about certain circumstances in which evidence won't be submitted to the LAA. Those cases of terrorism and indecent images. Of course, we understand that those cases exist and that you work very hard on those. But if you can let us know in advance that those files or the specific aspects of the PPE are of that nature, we can contact the CPS just to get confirmation of the figure, and that will help us speed up the efficiency and the processing of your claim. Box number 5. What was the
interject there, John?
Oh, of course, Jen. Yeah, no problem at all.
Just about the formatting. What I would say is, can the material be viewed is also a basic physical question. So, as you know, we are using Secure File Exchange for most of our claims in order to view the material, and Secure File Exchange does allow for a whole array of different file types to be uploaded. However, if you are submitting a small file, if it's less than 20 megabytes, it can be submitted via CCD, but just make sure that the file that you're submitting is in one of the compatible file types. If you're unsure what the compatible file types are, they can be found on slide 9, and also on CCD itself under the messaging box there is a small definition of the files that we do accept. So that's just something else to bear in mind, that there are different ways for you to submit that information to us. If for any reason the files are corrupted and we cannot physically view them, we do try to use our soft reject process where possible. So we will send you a message via CCD going, unfortunately, we can't view this file. Could you send it in another format? So we will try to take steps to rectify, resolve matters where we can. And sorry for the interruption. I'll pass you back to John.
Not at all, Jen. Thank you very much indeed. It's been really helpful to keep us on the straight and narrow. In relation, moving on to the assessment process, a caseworker will then look at what the defendant has actually been indicted with, and whether the material that you've been looking at in terms of the electronic PPE submission is relevant to those charges. The case of Sana discusses the case which is further on in your slide pack, just in relation to relevance and irrelevance. Obviously, the more relevant the material, the more akin to PPE it's going to be, and the more irrelevant it is in relation to the charges, more likely you'll be remunerated as a special preparation aspect. Then box number 6 we're looking at what was your defendant's role within the case. This usually comes in relation with whether the defendant has got co-conspirators. And one thing we would look at, that just because the material is relevant for a co-defendant doesn't automatically imply that it's going to be relevant for your specific defendant, depending on the role within the charges. That would be looked at in the case of Kadir, which again is further on in your slide pack. So please do take time to look at these cases, because they're very informative and they do support your PPE submission and the assessment processes that we do.
Can I just stop you there, John? And just want to interject again. What I would say is, when we're looking at the role of the defendant, we are looking at not just their role on the indictment, but we're also going to be looking at the stage they got at in the court process. So whether they've pleaded guilty early, or if they've gone to a crack trial, or if they've gone to trial with all of the other defendants, that is also going to have a key impact on our assessments and our thought processes. What we do try to do is, if you have a case that has got multiple defendants and they have all been on the same count on the indictment and they've all got to the same stage of the proceedings, we will make sure that our assessments are consistent. So some of the things we do try to do is cross-reference between the advocate fee scheme and the litigator fee scheme, and also check between entries submitted by solicitors and advocates representing the co-defendants. However, that can prove a little bit challenging, because, as you know, a lot of defendants don't always have the same T number for the case. So if you are aware that somebody has lodged their claim and they have been paid for their electronic evidence in full, could you please just pop a note into CCD and just tell us the name of the defendant? If you've got their MAC number as well, that's absolutely brilliant, because that will help us locate the record a lot faster, and it means that we can have a look at that assessment that's already been made, and providing that it's a sound assessment, we can generally apply that across the board to all of the other co-defendants who've been on that same count and got to the same stage of the trial, which does cut down a lot of time, indeed, and it proves for consistency as well. So that's just something to note. So I'll pass you back to John.
No, that's perfect. Thank you very much indeed, Jen. I mean, I think that kind of covers that second to last box for us very nicely. And obviously the last section is the significance of the material against the case defendant. If there is something that you viewed and you believe that is very significant specifically for your defendant, please do put down some justification onto the file when you're submitting your claim for electronic PPE, because we really will do our best to try and link that relevance to your client and the PPE final figure. Obviously, we do make a lot of assessments on claims on a daily basis across the teams, but you always have the right to appeal to us. Please try and submit that within 21 days as per the regs, and give us the evidence where you feel that we've made an error, and we can go back and double check that evidence and an assessment on that previous assessment process. If, however, unfortunately, we come to the same decision the second time round, you do have the right of written reasons available to you as well to the cost judge. Obviously, I think everybody would prefer not to reach that stage, because the written reasons process can be quite lengthy for those in terms of date of submission to when the hearing is actually heard. So obviously, if we can get as much information in relation to the appeal stage before we've made our final assessment, that will help both parties and help us in terms of quick turnaround of the bill, and also help yourselves in getting the full fee, or as close to the full fee as you applied for when you submitted the claim to us.
Thanks, John. So to say thank you very much for listening. I do hope you found it useful. I think some key takeaways would be to make sure that you do submit your claim to us with all of the supporting evidence required the first time round, as that will hopefully speed up the actual assessment process and make us do an most informed decision as possible first time round, which should lead to fewer appeals and complaints and correspondence. If you do have any queries, or if you do need any further information, please go to slide 30 of a pack, which has got lots of links for useful information. It's also got our telephone number and our email addresses for any queries that you might have. Again, thank you for listening to John and I, and we hope to see you soon at one of our future webinars.
Bye.
Bye.